The Court of Appeal and for the Fifth District of the State of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Thank you, Charlie. See if I can remember how these things all work and the curtains and all this stuff here. All right. Welcome. Good afternoon. As our marshal indicated, I am Judge Lambert. I'll be presiding over our oral argument session of the 5th DCA this afternoon. Join with me on the panel today. To my right is Judge Rand Wallace, and to my left is Judge Jim Edwards. We do have one case, one only. It's case 20-2739, Leslie Voiles as administratrix of the estate of Richard C. Baxter, deceased, versus Grace Ann Glavin and the estate of Bobby J. Kreisberg, deceased. I apologize if I'm mispronouncing anybody's name. All right, both sides will have 20 minutes. The appellant I'll leave 5 minutes for rebuttal for the appellant. If you want a different amount of time, just let me know and I'll reset the clock. You'll see as you're up there that as you get close to the end of your time, the things will start flashing at you, and I'll also give you a heads up as the appellant as you're getting closer to your rebuttal time. You can obviously keep going if you want. It's not weighted in stone, or you can stop earlier if you've said your piece. That's up to you. Also, anybody, if you have cell phones or any other electronic devices, we ask that you just either turn them off or put them mute so that they don't go off and disturb you or your opponent or the court during the course of the oral argument. That being said, if counsel, if you're ready to proceed, Mr. Wilkins, you can go ahead, sir.
May it please the court. First time I've been in the building in a year and a half, 2 years, it seems like.
Pretty much for us, too.
Forgot how big it was.
Yeah.
In any event, may it please the court. I will, 5 minutes should be fine on my reservation. Let me begin with sort of the review of the high points on this case. And the biggest, I think, issue, and the one I want to really point out, is the fact that there was such a lack of due process for Mr. Baxter in this case. There was a motion to tax fees against Mr. Baxter. It was a normal, what I would call a routine prevailing party type of a request for taxation. It did not mention ever in any word, deed, or otherwise that it was intended as a sanction against Mr. Baxter. It didn't mention the term inequitable conduct. It didn't say anything about the Bitterman case, which is apparently where this doctrine originated. Those things would need to be expressed. If you're going to basically try to tag a person for more than $200,000 in legal fees, it's incumbent upon them to basically tell you that that's what they're intending to do. They're trying to basically prove to you that they're going to be alleging inequitable conduct. They're going to allege that this is outside of the normal taxation of costs in any sort of a civil action. And so whenever you have that situation, I think you absolutely have to give the other side notice. We got no notice. In fact, the first time the Bitterman case was mentioned was at the hearing itself. That was a complete and total surprise to me. And as you'll see from the record, I was so convinced on the legal position that we had that there was no basis to tax fees against my client that I filed a 57105 just to try to avoid the hearing on that particular issue. And I went ahead and noticed that at the same time as the fee hearing. And to move on to the second point, there are clearly errors in the final judgment as I analyzed in my brief, beginning with page 28. And it clearly fails to comply with the Moakley decision, which is sort of the expansion or the clarification of the Bitterman decision. And it basically says, look, if you're going to sanction somebody for inequitable conduct, there has to be sort of a nexus, if you will.
Was Moakley just limited to the conduct of the attorneys when they?
No, it's not. In fact, no, it's not. It's not. In fact, there's a case from this court that basically says exactly, in fact, I'll read it. I didn't cite it in my brief, but I was afraid you might ask that question, and I found a case from this district. It's the Allegheny Casualty versus Roche Surety case, 885 Southern 2nd, 1016, and I'll quote from that case. The amount of the award must be directly related to the attorney's fees and costs that the opposing party has incurred as a result of the specific bad faith conduct. The requirements of Moakley also apply when the attorney's fee award is to be a sanction against a party pursuant to Bitterman. So this court has basically already said that Moakley applies, and even when it's not involved in sanctions against an attorney. So I think that's clearly the law, and certainly in this circuit, and I think that's essentially case law elsewhere too.
Well, how do we know whether the judge was tying the attorney's fees to conduct, since we don't have a transcript?
Well, if you think about it, what conduct would there be? Look at the record. You've got all the pleadings. There's only one deposition taken in the whole time. Everything that happened in this case is in the record, except for that deposition, and the transcript of that deposition was also in the record. So you can see what actions or lack of actions that was taken by my client, and it's through me. I'm the ones filing those pleadings. And frankly, personally, it offends me that this was ever raised as an equitable conduct on the part of my client, because I don't think there's any basis to support that in this record. The lack of a transcript, I can tell the court, the lack of a transcript is not going to matter, because it's the record that was before the court that would evidence the inequitable conduct, if in fact there were any. And if you look at this record, this is I'll call it a garden variety lost will and will contest. That's all it is. And to basically have a client take reasonable positions, in fact, reacting to an adversary proceeding filed against him, to react by filing pleadings, basically making the alleged personal representative prove her case, that's not inequitable conduct. He was dragged into this case. Yes, he counterclaimed to set aside the will that they were trying to admit, but that wouldn't have even been necessary.
What was the adversary pleading filed by the personal representative, or the soon-to-be personal representative, or eventual personal representative?
I'm sorry.
You said that you filed a counter.
Well, in essence, the petition to admit a lost or destroyed will. That was the adversary proceeding? Is an adversary proceeding, and that's what she had to file. And if you look at the pleadings below, you'll see she's the plaintiff, if you will, in that adversary proceeding. My client and the other charities are defendants in that proceeding.
So the chronology, she filed, and eventually the probate judge entered an order admitting the will, but then saying, but we'll address the issues, the contest of the will later. How did that come about? That's kind of an odd...
Well, procedurally, I think that was incorrect, but it may not have made any difference.
They admit the will, but then we're going to address whether the will should be admitted or the objections to the admission of the will down the road.
Well, I don't think he really admitted the will. Basically, I think what he essentially did was say, okay, we've got the evidence we need to basically establish a lost will. We're not saying that will is going to be admitted.
Now we'll deal with the incapacity and all the rest of it, right?
On a later date.
This is the will we're going to talk about, so, okay.
That's correct. That's correct.
In terms of attorney's fees, were there any duplicate billings or things of that nature contained in the affidavits, or did you look at that?
We didn't even get to that point. To be honest, both sides at the conclusion of the hearing, both sides were asked to submit proposed final judgments and proposed findings of fact. And the judge gave us about 30 days, I think, to do that. And both of us did that, and within 24 hours, Judge Galuzzo signed the order that was submitted by the other side. But what you do know is, look at those fee petitions, whether it's duplications or not, there certainly probably are, but they tax every penny in this case. What is this supposed to be, a probate that's carried on the back of my client, who's not even a beneficiary? I mean, the result was just absurd to basically tax all those fees. And Moakley, I think, specifically requires a matching of those. Tell me what you think the egregious conduct was. Be specific about what the conduct was that you think should be sanctioned, and tell me how much time that cost the other side to pursue. That's the way you sanction. That's the way you determine under Moakley and Bitterman.
According to the record, were the attorney's fees going to be determined based upon the affidavits that had been submitted? At the November 10th hearing, in other words, there was an expert I know available to testify, but in terms of the bills themselves, those were being presented through affidavits, no live testimony.
That's correct. They were filed those right before the hearing. I mean, it wasn't very long. They didn't file them back when they filed the motion. In fact, they went through some analysis in their motion to indicate that they had the right to file them later, and they did eventually, because they were obviously substantial. I mean, they're that thick.
So the only live testimony at that hearing was of the PR?
That's it.
As to fees? Was it a fee hearing, or was it?
It was a fee hearing, essentially. And keep in mind, too, Judge Galuzzo was not the judge in this case from the beginning. Judge Alba was, for the most part, the judge when a lot of this stuff occurred at the beginning. And to have Judge Galuzzo, essentially, he just had to take the record just the way it was. I mean, he wasn't participating, he wasn't involved as a judge in all of those earlier pleadings and the earlier hearings and the earlier events. And so there was no attempt to say, okay, you should not have objected to the entry into the safe deposit box. And as a result of that, we're going to tag you for 2 hours of legal time.
So from a chronology, I mean, I look back, and apparently the will was admitted by a separate order in February of 2020. And it says, but the letters of administration will not be issued until the challenges to the will are resolved. So I'm unclear as to that theory. But in any event, that's what happened. And then at some point, I mean, there's no motion for fees against your client. Your side eventually, about a week before the trial, I guess, files we're withdrawing. We're not contesting anything anymore. And then shortly after that, then, the order appointing the PR and the letters of administration are issued shortly before the scheduled trial. So that basically concludes everything as it applies to your client, because your client's not a beneficiary. And so at the time he files, or you file on his behalf, the withdrawal, he has no reason to believe that there's going to be a request for significant fees to be imposed against him. And that comes down a few weeks after the order appointing the PR and letters. That's when the motion gets filed, and that's when the swords are drawn at that point.
That chronology is absolutely correct. And again, this lawyer standing in front of this court will advise my client, if you're not a beneficiary, there is no basis for taxing fees against you. Mm-hmm. And therefore, dismissing it is essentially a matter of a ministerial act at this point. And keep in mind also, it wasn't as though my client didn't get anything from the litigation and the pleadings and the curator, et cetera. The curator found $31,000 for my client, as well as around $90,000 for the estate. And had we not taken steps to basically impose that curator, charge him with the responsibility of trying to find assets, my client benefited from all of this. And we were not at all convinced Ms. Glavin was going to be able to do that, because she was basically in charge of the store when the accounts were escheated back to the state of Florida to begin with. So, you know, it's an odd situation in the sense that, you know, as lawyers advise their clients on what they should and shouldn't do based on what had happened. My client had received what he was going to receive under that litigation, if you will. The curator had given him a check. His job was essentially done. He did as much as he could to vindicate it.
Now, under the 1999 will, he was the nominated PR. Was he also beneficiary?
He was, but it was as to the real estate and personal property.
Along the way.
She sold the real estate.
Sometime between 99 and before her death, obviously.
There may have been some personal property that he was still entitled to. But again, the question of standing, if the question is one of standing, this court already has ruled on that as well in the Wheeler case. That basically a prior nominated personal representative, you don't even have to be a beneficiary, right. Just a prior nominated personal representative has standing to challenge a later will. And again,
find the 99 will?
We never got to that point, but no one found it. No one found it.
And in the final judgment, was there ever a challenge, or did you ever refute the allegations that were put in the final judgment as far as your client's conduct?
Well, we didn't file for rehearing or reconsideration. We did in our proposed final judgment that we submitted to the court. We did lay out the grounds on which we thought the attorney's fee should be denied. And his conduct was not even one of them because, again, we didn't know that was even going to be the issue in the case prior to the hearing. So, no, I didn't refute any of that. In fact, I pretty much appealed that case, that ruling, I mean, right away. We didn't even wait the 30 days. I went ahead and appealed it right away.
The appellee has said that since the probate was still ongoing, your client withdrawing his objection wasn't the same as the other voluntary dismissal cases. What do you
Well,
have to say
I
about
agree
that?
there's no case that deals with this particular issue, but let me point out this. First of all, start with the basics. Probate is an in rem proceeding. It is not an in personam proceeding. That's why all those statutes that he cited are statutes that apply to a beneficiary's interest. If they challenge a will and they lose and they're in a prior will, or they're in the will that is challenged, they can be tagged with those fees. Second, there is no service of process in this case. There's no summons ever issued that would effectively make personal jurisdiction over my client. He was served formal notice, certified mail. That is not the same as service of process. This is an in rem proceeding. It's not an in personam proceeding. There's no reason why he would think that he was exposing himself to $200,000 of damages by simply participating in the lawsuit, participating in the adversary proceeding. It's just impossible to understand the basis on which the court could conclude what it concluded here. And again, look at what was filed. There's nothing in there that was at all out of line. The discovery requests were reasonable, even though they were objected to every time. The odd thing is, once we got the curator appointed, Ms. Glavin objected to my client. This is before she got appointed. Objected to my client getting the records that the curator found. She could get them, but we couldn't get them. I mean, what is that? I mean, it was...
What was the basis for the objection? Why did she object? Well, I mean, okay.
Because the trust was not at issue, was one of the reasons.
Was there a discovery request that wasn't objected to?
I don't think there was. I think they objected to every discovery request we propounded.
What
And-
about your client? Is there a discovery request that was not objected to by your side?
Off the top of my head, I don't recall there being any objections made by us against any discovery request.
A lot of requests for your client's ID that I think were objected to.
There were. That is such a red herring because
So what was the point of that? I mean,
I can't tell you. I can't tell you the point of all that.
was it disputed that he was the brother?
No, not that I was aware of. She served him. She's the one who served him at his address, and he responded. She knew who he was. He didn't have a photo ID. He was a simple guy. He's no longer with us anymore. He was a simple guy. And, you know, this was, to him, an outrageous circumstance because of what he knew about his sister and his sister's condition. I'm already down to...
You're into your, if you want to keep going or you want to stop?
I would like to reserve the rest of my time.
All right, very well. All right, you got 4 minutes, basically. Okay. Counsel?
Good afternoon, Your Honors. May it please the Court, Alan Taylor on behalf of the appellee, Ms. Grace Glavin. I'd like to first touch on, I think, what was as Mr. Wilkins started out with what he referred to as the biggest issue, this issue on lack of due process. You know, the idea of this concept of due process in this particular instance shows that...
Let's make sure we're clear. I mean, I think his concern from a due process is there's a motion for fees that doesn't mention inequitable conduct at all, period, using those terms. I mean, it talks something about chancery, which I would suggest is not your best argument here this afternoon, but that's up to you.
No.
And so so his due process saying, I have a motion that says these are the reasons I want to get fees against this client, and he analyzes it and says, well, there's no bases under any of these to do that, which apparently proved correct because that wasn't the basis for any award of fees, so.
Right, the motion starts out with the under principles of equity or in chancery, which obviously the inequitable conduct doctrine is a subpart of. Now,
Oh, that's not obvious, certainly not obvious to me, so that's one vote against that, but.
yeah,
I mean, to
well,
me, that's
there's a
like saying
Florida
we're
Bar
going to
Journal.
proceed under the laws of Florida.
Right.
Or, you know, or at the end of every pleading, you always put in such other relief as the court might find meet and just back in the old days. They probably say appropriate nowadays, but, you know, I had a concern with that too. The bases that's contained in the motion to tax cost is section 57014, which was not used, 57105, and y'all had not served at 57105. 733-106 only applies to beneficiaries. 733-609, you know, again, is more beneficiaries and challenge to the operation of the estate by the PR. Rule 1420 and 1525.
Right.
You've got all that. There's nowhere in that motion bad faith. There's nowhere in that motion sanctions. There's nowhere inequitable conduct.
There was a 57105 motion filed, I believe, in October of 2019 in the record. I would also address, and I understand those concerns, certainly, but looking back, you say, okay, October 1st. Well, first of all, the motion itself was filed, I believe, October 22nd of 2020. The hearing was November 10th. The hearing was set for October 1st. It was 40 days' notice. Obviously, the or the appellant filed and I believe that was on October 22nd, in response to the motion for taxation. All right, and in that he cites to a couple of cases there, the Anderson versus McDonough and the Heritage Found, actually it's the way it's worded, versus Schmidt. Both of those cases in which he elaborates this is not a circumstance where the inequitable conduct doctrine would be applicable. And in fact, Anderson, of course, he cites to these cases, he refers to Bitterman. So in the sense of that being on the table and him, Mr. Wilkins, who is a board certified, highly, respected probate and estates trust lawyer and all that, and I've had the pleasure of working with and against Mr. Wilkins for many years. So you take a look at the totality of those circumstances. Now, if Mr. Wilkins or the appellant had wanted to perhaps set a status conference, what's this going to be about? In fact...
Why would he do that?
Well, no, I would agree.
I mean, he sits there and says, here's the motion. This is
Right.
what they're asking for relief based on that. He analyzed it. You just told us what a wonderful
And
lawyer he is. And he
Perhaps
says,
he didn't need to. Perhaps the
it
appellant
sounds
didn't
like
need to because
it
they
sounds
addressed...
like he had... You probably need to stop when I talk,
Yes,
and
ma'am.
somehow that works.
Or sir. Yes.
All right. I mean, so he sits there and says, okay, I've analyzed this. There's no reason for me to do anything more. I don't have to have my client here. There's no grounds asserted which they could possibly get fees under, which he proves correctly because the judgment makes no reference to that. So he analyzed the motion correctly, except he comes on the morning of or the afternoon of the hearing, and all of a sudden inequitable conduct doctrine is there, and he thinks that's a due process violation, which seems to be the epitome of one. I mean, tell me why that's wrong.
Because of the issue he was responded to in reference to his response to the motion, in which he cites the cases that do address that, and he says that this is not the circumstances where this conduct would rise to that level.
So he agrees with you all because you didn't seek it.
No. Well, I'm not so sure about how to, I mean, what my point being is notice an opportunity to be heard.
So your benefit, so you're saying, thank goodness he's a very thorough fellow and points out things that haven't been raised that don't apply here,
Right.
and therefore I'm going to ride those coattails and not actually put it in my motion, and that's going to be ultimately the successful reason why we get $220-some thousand in fees. That's the okay due process position we're talking about?
And of course, Your Honor, we had submitted those affidavits in advance of the hearing as well, which reflected, the time and charges incurred in regards to that.
Do any of them say bad faith, inequitable conduct, that
Yes, sir.
sanctions ought to be? I mean, they're just regular routine things, and
Which you would file, which makes sense. You're saying we want fees, and here's the fees we've been
here's our
incurred.
basis, and if we're good, we get them.
Here's the hours, here's our hourly rate, Judge, and here's our evidence, and you all agreed to use affidavits, so that makes perfect sense on your side to file that.
And again, the court provided the opportunity to the parties. These were all issues that were argued at the hearing, for which we don't have a transcript, and we've cited to, for example.
You're going to argue, you're going to tell us about something that's not in the, that's.
No, sir. And that's the difficulty here. I'm also constrained by the incomplete record that's here.
Well, you could have completed it. You could have supplemented the record if you wanted.
Right,
to.
but
Right?
the appeal comes, the order comes with a presumption of correctness. It's the burden on the part.
Sure.
But again, what the court did is come back and say, look, arguments as reflected in the judgment at issue here, he talks, the usual language that you find in the initial part about arguments of counsel and stuff. So then you go into what the court said, the parties agreed not to utilize Mr. Brian Phillips as the expert. I can decide the reasonableness of the record and stuff, and that's in the final judgment. And everybody submit their formal closing arguments to the record so many days, whatever it was, which both of us did. So I would suggest that, given the record as we do have it, that certainly we comported with due process in that sense.
What about his other argument that he analogizes it to, there's a voluntary dismissal, there's no motion for sanctions filed before the voluntary dismissal, therefore under our case law, Buckingham Estates case, although that wasn't a probate case, there's no jurisdiction. I think Judge Orfinger wrote the opinion that there was the issue, the writ of prohibition, that you can't go forward. Tell me why that isn't not directly analogous or somewhat analogous to the scenario here, that the litigation ended. By the time the motion was filed, the actual adversary litigation ended. They withdrew their claim. Your side got, the PR was appointed, the letters of administration. So,
right.
So now we're just administering the estate.
Right. And in terms of that, Mr. Wilkins, or it was referred to in some way as analogous to a counterclaim. Certainly one can suggest that, but it also is, to me, kind of a hybrid involving affirmative defenses. The judicial labor had not ended in the sense that we had a petition to administer the estate.
The judicial labor in the adversary proceeding had ended.
As far as the affirmative defenses, but overall.
To everything.
What other litigation was there after he withdrew his objection? What other litigation was there?
The litigation involving the trust, which was filed as a civil action and was pending before
case, right?
Judge Lester. It's
Separate case.
separate, yes, sir.
Okay, but in the probate litigation, which is that you got your judgment for the probate litigation, right?
We got letters issued on August 4th.
You got attorney's fees. The $220,000 in attorney's fees was in the probate case, not the trust case, correct?
That's correct.
Okay. So by the time they withdrew their objection, the litigation had ended in the probate case.
The litigation with respect to the objection to the probate, that's correct.
Right, because you got the letters admitted, issued, and the order appointing the PR regarding the will a couple days after they filed. So you had obtained what you were seeking to do. So everything was done from an adversary proceeding point. Now it was just finalize the administration of the estate, the non-adversary part of the estate. So you don't get fees for the non-adversary part, right? There's no reason to tax somebody who's not a beneficiary for the estate, right?
Cost of administration. I mean, the routine, filing a petition, getting the letters, gathering the assets, dealing with creditors. That doesn't get charged to get somebody for a will contest.
And,
right?
and that had yet to be opened. There was no estate for the 3 years or 2 years and several months pending.
Tell us again, there was no more litigation. And
there was no more of the litigation over the objections, right. And the letters were issued a week or so.
There's no more litigation in the probate case, period, correct?
That's correct.
And there was no motion filed by that time. I mean, it was finished. The motion was filed about 3 weeks after the letters. Okay, so at that point, that's the first time he's got any reason to believe he's going to have an attorney fee sanction imposed against him. And if this was a civil arena when the case was over, dismissed, then we have case law of our district that says too late. right?
There is case law, and we would,
Maybe I made that too broad. There is.
Right.
It's not, I'm looking at it,
Yes, sir.
Orfinger wrote something.
Yes, sir.
So, all right, so we have that. So, Mr. Wilkins is saying, although we don't have an identical apples to apples, we basically have a very analogous scenario that the principle of law should apply here. No motion for sanctions filed. The litigation, the adversary litigation, the probate ended without a motion being filed. Therefore, there's no more jurisdiction of the probate court to impose sanctions, even though the probate court does still have to finish the administration of the estate that doesn't involve his client. That's what he's arguing, as I understand.
that's the argument. and-
Why isn't that quite logical?
Well, there was a pending motion for sanctions that were pending as with respect to fees and costs previously.
But that's not what you
But that
won
was,
on.
that's right, that was under
Because there was
the,
some issue, there was no safe harbor letter.
right.
Oh,
Well,
which was why you.
I don't know, I wasn't involved at that,
I'm
I
not
got in it
picking on
towards
you,
the
I'm not
end.
picking on you, but I mean, that would have seemed to me the more logical route to take, to say, hey, we did a 57-105, we did a safe harbor, they didn't withdraw their thing. Katie, it's filed before it ended, so now the court has jurisdiction to address that. We probably wouldn't be having much of a discussion, and we wouldn't be having an oral argument about it. But that's not what happened here.
Well, again, without pulling up the exact citation, but my understanding was back in October, I think in 2019, the actual motion, a motion to tax fee was filed by by Heather Kierson.
But that's not the motion that was heard November 10th.
Well, it was cited to it, but the court found the inequitable conduct doctrine.
Okay, well, you didn't cross appeal saying, this might not bear well for me, but the judge didn't rule in favor of me on the 57-105 when it's still the same. I could still get fees under that, and that was timely filed, so you can't ride that horse.
Right.
Okay.
I mean, the Almazan case was a probate case, and the same thing there. They said where the motion wasn't filed before the voluntary dismissal, you can't seek fees as a sanction, correct?
Right. But here, again, our position is simply that the judicial labor had yet to end in connection with the process that had been delayed those 3 years with an extraordinary amount of fees and costs that were incurred.
Well, don't the cases on the inequitable conduct require you to tie one to the other? So you're talking about there was still stuff going on that had nothing to do with inequitable conduct.
But none of that was sought as far as fees and costs in connection with
Right, so all the inequitable conduct that you think may have occurred already had occurred. There's no further litigation,
Oh,
there's
yes,
nothing
that-
happening.
That's correct.
So, again, the Almazan case, the Pomerantz case, they all talk about the fact that, once a voluntary dismissal is taken, unless the motion for sanction was filed before the voluntary dismissal, the court loses jurisdiction, whether to consider a late filed motion or to rely on its inherent authority to sanction bad behavior. It's over. And that's what I'm having a lot of trouble with here. Why wasn't it over here when he withdrew? And the only answer I hear, and the only answer I saw in the brief, was because the administration of the estate was continuing. Is there any different answer than that?
The administration of the state was continuing, right.
Right. Okay, and that's the only thing that was, okay, that's fine. Let me ask you
That's
on
clear on the
did Judge Galuzzo in fact award every penny of the attorney's fees, other than I saw there was some not well-described discount or something that was taken, but generally was every penny awarded?
That was not otherwise subjected to discounting. That was in the actual time records submitted, yes.
There were
It seems to
several duplicate bills, and by that I mean there was a bill for, there were two bills for June, say, exact same bill. There were, and I'm looking at that, page 1011 of the record and 1005 of the record are the exact same bills. So I'm certainly not accusing the law firm of double billing, but somewhere along the line, whoever assembled the affidavit for the attorney
Right.
put the same bill, exact bill in there twice, and they did that at least 2 times. They did it for that one in June. They also did it in July. And it concerns me, since we don't see Judge Galuzzo's calculations, and none of the affidavits filed by the attorney said we charged $80,000 or anything like that. It concerns me when I see duplicate bills, exact copies of the same bill in there more than once. That to me is a problem, and I can't tell from the final judgment because it just says I award X dollars, but I give this little discount kind of a deal. So.
Yes, sir. And again, that could have been a duplication error in terms of a copy machine or from the source.
Right, I'm not claiming
I
any
do-
ill will, but the thing of it is, it's in there twice, the attorney's affidavit, and it's numbered consecutively in the record.
Right.
The attorney's affidavit said, we incurred all the fees and everything else attached to here, and my concern is, since we don't see the breakdown, we have no clue whether the judge double counted it, whether somebody brought it to his attention that there were duplicate bills or anything else. So.
Now, Ms. Glavin also had filed her affidavit as well, so we could cross-reference that to determine, to that extent. But certainly I would agree, if there's duplication, that should not be counted, obviously, in connection with any kind of order. So,
And the problem is the final judgment is so facially flawed because there's no finding of a reasonable number of hours or reasonable hourly rate. And it's just puzzling, I guess, to me and to some of us, is that you've had to do that since Roe, since 1986. And here we have a judgment that's on its face wrong, just wrong.
and there's,
And I know you try the best you can to backtrack and say, well, he kind of made these findings, but it's not easy to say, well, I can look at all these affidavits and add, get all my calculators out and add it up, and it comes to that number. And that's just, that seems reversible on its face, regardless of whether you have a transcript.
and the case law does.
From our case, from our 5th DCA.
And that's,
He lost in that case.
I agree with that as being, the idea is that when that does happen, or when there have been cases that have reversed on that basis, it would be remanded to make those specific findings and to, go forward with determining that reasonableness so that the record would be more clear on the reasonableness of the hourly rates and the time exposed and the tasks devoted to that.
Your argument in your briefs is it's fine.
Yeah.
The final
Well,
judgment's fine.
the-
It's not.
It's not remotely fine.
Yeah, the court had, the basis for that approach is that, well, the court, everybody, as noted in the final judgment, said, okay, here you go, Judge. We're out of time. I believe that, and without looking at the minutes, I think we went close to 5. I think it may have been quite overtime.
Okay. But
And it was
doesn't
submitted-
matter to
It
us.
doesn't matter, we don't have a transcript, we don't know what was talked, whether it was 2
That's-
hours or whatever.
And whether it went after 5 was so okay.
And it was your final judgment, your version of the
Your
final
side
judgment.
prepared it that he signed, according to your opponent here, right?
Right.
I'm not saying you did, but I mean,
Closing argument, right.
Were there any revisions to the final judgment that you presented to the judge in draft form?
Other than what we presented at the hearing in respect to the affidavits.
Right, but there was not a final judgment that broke it down for law
Each.
firm A, for this lawyer, reasonable rate is this, and reasonable hours
No,
or
sir.
that, and so on and so forth, which,
jumping back to the due process, doesn't the principle of law make sense that here's a person saying, I've got no motion for fees pending against me, I have a trial coming up, I'm going to make a business decision or a health decision or whatever decision, I'm just going to give up and I'm not going to contest this anymore. And it seems like a height of the due process violation to say, and oh, by the way, when I'm making that, it's one thing if he's got a motion saying, I want a bunch of fees against you when you're making this decision to withdraw your objection. He doesn't have that. He's got this here saying, I can go forward and go on my way and be done with this case, and that's the choice I make. And then all of a sudden, 3 or 4 weeks later, he gets a motion asking for $220,000 against him. If he knew that ahead of time, he could have maybe decided, I'm going to continue to fight, and maybe he would have won. And then he wouldn't be looking down the barrel of a $220,000 judgment. That just seems to be the epitome of what the whole due process concept is in American jurisprudence. Forget about just here in Daytona, or wherever this was. Isn't
Right.
it? Doesn't that make sense? I mean, we can parse about it, but I mean, isn't that really the heart of this?
I think that does, yes, of course, but I would also point out that overall at the overall posture of the matter at hand, you did have the prior issue in reference to the motion on the fees based on the 57, whether it was addressed or decided not to be addressed. So there was actually notice of that issue, and,
Which he won on, apparently, or you didn't win on, so whether he won or he didn't lose on that, so. All right.
That was not the basis for the award, so.
right, no, that's
All right,
true.
we won't beat that.
I agree.
All right. The clock's over.
Oh.
If you just want to wrap up, you have 30 seconds to wrap up.
Well, I think, again, that the record itself, as it exists, is incomplete in the matters. I would just also point out, of course, to the case of Rosenberg versus Gabala, which was cited in regards to the lack of a transcript. It's tough to make how much of the record
Again,
is
on
and
the-
is not.
On your motion, the basis for your motion, which the rule requires you to set forth the basis of the motion, he looked at that, analyzed it, and said, no problem, this is a slam dunk for me, my guy's not a beneficiary, why am I going to hire a court reporter? And on the morning of the hearing, I guess it's the morning of the hearing, shortly before the hearing, you guys give him a list, and I assume cases attached, so it's not like it occurred to you guys as you were walking in the courthouse, hey, there's this inequitable conduct thing. I mean, y'all had given some thought to it ahead of time. When I say y'all, whoever the counsel was at the time, and yet chose not to give them a heads up before you walked into court.
Well, we did consider the totality of all bases. When you received the October 22nd response to that, you're saying, okay, he's getting into that territory in the inequitable conduct doctrine and arguing on the merits on that particular issue. And there's really not, the Bitterman is really the only case out there other than the Moakley, and, you've got the Rosenberg versus Gabala, for example. And so from that circumstance, there wasn't any effort to sort of slip things through. Rather, it was simply presenting the arguments that were there to include Mr. Wilkins' arguments in opposition, which he was prepared to make.
All right, well, thank you.
All right.
Thank
Thank you, counsel.
Unless you have questions, I'm ready to step down.
You have any questions?
Nope,
Good.
thanks.
Thank
Thank
you.
you.
All right. All right, we will stand adjourned. All right, thank you.